Let's get to the legal landscape. Our legal analyst, attorney Dan Adams, joins us every Monday to break down the biggest cases happening across Wisconsin and the country. He joins us now. Dan, it's good to see you. Last week, the Wisconsin Court of Appeals ruled that a Milwaukee boy charged with killing his mom when he was just 10 years old cannot be tried as an adult. This ruling could have impacts far beyond this case. Tell us why the court ruled this way.
Sure. Good morning, Jaron. Yeah, we've been following this case for 3.5 years. In November of 2022, this then 10-year-old allegedly killed his own mother over a fight about a VR headset. In Wisconsin, under Wisconsin law, a first-degree intentional homicide is waived from juvenile into adult court. So the presumption is that it's going to be adult court. Juveniles are able to claw this back in something called a reverse waiver hearing. It's a fact-intensive hearing before juvenile court where they go through 3 factual factors about this juvenile, about the specifics of the case, and the burden is on the juvenile and his lawyers to put forth facts that show that adult court shouldn't be where this juvenile is. So they went through all of that. This is actually following a competency hearing for this child. They went through this fact-intensive hearing. They had social workers, psychologists, members of the Department of Corrections come and testify about these 3 factors. And the trial court judge, our circuit court judge, said, no, the factors have not been met. The child has not carried its burden, and this court doesn't have jurisdiction. So go back to adult court. Well, the Court of Appeals said, you didn't take into account enough of the unique factors of youth, which the Supreme Court has talked about in an 8th Amendment circumstance, and you just didn't apply it here. And so they've taken it back and they've said, no, you have to apply the circumstances of youth that the Supreme Court has talked about, apply it in this case, really going after a 30-year-old statute here. Very unusual for the Court of Appeals, which is our interim court before the Wisconsin Supreme Court, to do. Now we wait to see whether or not the state of Wisconsin, through the Milwaukee County District Attorney's Office, is going to appeal this to the Supreme Court, or whether they're going to have this reverse waiver hearing again, and whether this now 13 or 14-year-old will be tried in adult or juvenile court.
Yeah, definitely a ruling that could impact how those reverse waivers are handled in future cases as well. Dan, next, nationally in 2025, there was a surge in executions across the country, reversing near historical trends. How is the Supreme Court treating this trend, and what can we expect in this new year?
Sure, Jaron, this is a huge surge last year in death penalty executions. 47 people across 11 states were executed by the government last year. That's the most since 2009. So yes, historically, a very big year for executions. We can look at Florida alone. They had 1 execution in 2024, 19 last year. So that is a lot of these. Other states like Arizona had moratoriums on their death penalty sentences. They have stopped that. They were looking at the processes in which they were carrying out these executions. And the Supreme Court last year granted no relief. We're used to these kind of Hail Mary, last-minute appeals to the Supreme Court, emergency appeals. 34 of those 47 people that were put to death filed an emergency stay, and all of them were denied, including one man in Alabama who wanted to be put to death by firing squad rather than hypoxia. So the Supreme Court was not doing anything for anyone on death row last year. This year we have several executions scheduled, 16 of them. We'll wait and see whether or not any of the last-minute stays are granted by our Supreme Court this year.
Dan, it's always great to have your insight and analysis. We'll see you next Monday for more of The Legal Landscape.